Just these two paras, very short paras, at para 9 and 10, it is submitted that as per records available, about 52.31 lakh displaced persons from former East Pakistan had migrated to India between 1946 and 1971. Out of these, the displaced persons numbering 41.17 lakh who arrived up to 31st March 1958 were called old migrants, and those who arrived between 1164 and 25/3/71, numbering about 11.14 lakhs, were called new migrants. Out of the 41.17 lakhs old migrants, about 31.32 lakh were settled in West Bengal and 4.87 lakh persons in Assam. Out of the new migrants numbering 11.14 lakhs, 2.12 lakhs persons came to Assam. The remaining old and new migrants were rehabilitated in different states of the country under various schemes of the Government of India. Wide range of relief and rehabilitation measures were undertaken by the Government of India for rehabilitation of old and new migrants. The rehabilitation of old migrants was by and large completed by the end of 1960s, and that of new migrants in 1980s. It is submitted that the state of Assam also witnessed migration from other provinces of undivided India even before partition of the country due to economic reasons. And your lordship will see this decadal variation between 1911 and 1951 or 1961. There's a huge amount, much higher than the national variation. The decadal growth in Assam, 1911, 1921, etc. Now, historically, this has been well recognized, and in my written submission, I've set this out, that even in the 19th century, leave alone the 20th century, there was a lot of Bengali settlements in Assam, and it led to a lot of disquiet because at one time Bengali was made the official language for about 12 years in the 19th century. The British had made it the official language of Assam. That had led to huge resentment. So every time Bengalis settled in Assam, this has nothing to do with Pakistan or India. This is way before independence. There was always resentment. There was always an upsurge of this fervor, and rightly so. So I'm only pointing out this has to be kept in mind. Yes. This alarmism has a historical background to it, which must be kept in mind, because ultimately human beings in large numbers get affected by an alarm against a race, not people from Pakistan, but a race of people who happen to be settled over there over the last 150, 200 years. Deeply obliged.
Thank you, Mr. Singh. Only one. Mr. Trivedi, you are for the ASU.
Well, para 9 may be seen with para 40.
Para 14.
Of course, numbers, my lord, may not decide the validity, but
let's see that. Now, 14 also read out 49.
14 is the Rajya Sabha. Yes.
That Rajya Sabha clarification. That was based on hearsay. The clarification.
The learned solicitors, para 1 to 6 are very clear in your submission.
She is appearing for Ms. Malvika Trivedi.
My lord,
ASU in writ petition civil 562 of 2000.
My lord, respondent number 6 in writ petition 562 of 2012 and respondent number 5 in writ petition 876 of 2014. My lord, my one-pager written submissions are in volume 2C, pages 7 to 8, PDF 910.
Page number?
PDF page 910, my lord.
Volume 2C. Huh?
Pages 7, 8. My lord, just to give a brief background on All Assam Students Union, because a question had come from the Honorable Court that why Assam and why not West Bengal? The answer lies herein. It is because of this long agitation from 1979 to 1985, my lord.
To read that note, I will.
Please, my lord.
So that's
the first part of my note, and also because.
Let's read that. It's important, yes, actually.
Yes.
Let's read it.
So, my lords, the first point, the backdrop of the Assam Accord dated 15th August 1985. The Assam Accord was signed between the Union of India, State of Assam, All Assam Students Union, and All Assam Jan Sangram Parishad in the backdrop of a 6-year-long movement, 1979 to 1985, in the state, against the unabated illegal migration of foreigners into Assam, their settlement in Assam, and their inclusion in the voters' list. During the agitation, about 860 persons who are considered as martyrs during the Assam movement lost their lives and thousands were injured due to police action. Very recently, the Martyrs' Day was actually in commemoration of these people who had lost their lives was held, my lords, in Assam. The state suffered tremendous political uncertainty with 4 changes of government and 3 spells of president's rule during the 6-year period. And this is very important, my lords, clause 13 and 14 of the Assam Accord, because this is on restoration of normalcy, which is the underlying concept under section 6A. That is the purpose it was brought into, for the purposes of restoration of peace and normalcy in the state of Assam. And a book that sums it up, The Quest for Modern Assam by Arup Jyoti Saikia, which is also a part of the compilation. It has 2 chapters on each and every meeting that had gone on that time with the government and with the All Assam Students Union. The run-up till 1983, thereafter in 1985, after the Prime Minister's assassination, then in 1985, what were the events which led to the agreement behind this Assam Accord, and then it came into play. And the background that was discovered was also discussed, and when finally agreed upon were the 1964 riots which had happened in East Pakistan, where there was mass massacre of the population, and therefore they had escaped into India. So therefore they became a part of the 1967 electoral rolls. So therefore that part of the population that had come in at that stage was included, but the part after that, then the government agreed would be kept disenfranchised. Therefore, the period till 1971 where they were not included in the electoral rolls. So therefore, in the history of this entire accord is the agitation, and therefore the difference between West Bengal and Assam for the purposes of this particular section. Now coming to my second point, where a lot of arguments were raised by the petitioners on the infiltration continuing. For that, I just want to point out one para from the reference order itself. Para 46 is very important, because the point that we are making here is that the constitutional vires of a statutory provision cannot be tested on the basis of faulty or inadequate implementation of the said provision. And if my lords will only have para 46 of the reference order, it says, if I may just read the introduction, on an overall consideration of the immediate dimensions of the issues and the potential that the same have for the future, we issue the following directions under Article 142 of the Constitution of India. 1 is border fencing, border roads, and provision for floodlights. The second is foreigners' tribunals. The third is existing mechanism of deportation of declared illegal migrants. And in that, 48.1 preparatory work such as selection of vendor system, development by system integrator, appointment of staff and training, etc., has already been directed to be completed by the end of January 2015 by order dated 27/11/2014 of the court. 48.2, the remaining work of updating the NRC will now conform to the following time schedule, which will be strictly adhered to. And 49, all the cases, so on and so forth. So therefore, if my lords will see that this is the implementation that had to be carried out as per the Assam Accord, the absence of this implementation cannot be a reason to fault section 6A. Then coming to the third point, which has already been addressed, so I will only talk about the case law very briefly to say that the petitioners are also disentitled from claiming the relief on account of inordinate delay. And for that, I only want to point out that whether it is Ram Chandra Shankar Deodhar, whether it is Rabindranath Bose, or whether it is Trilok Chand, the underlying concept in all these judgments is that if the rights of another set of people have already got created, then the delay in filing the petition cannot be then waived off. And my lords will just see, I have just given a few instances when they could have challenged and they did not. And therefore, these rights have now crystallized over 40 years. One instance that I've given, the report by the Lieutenant General S.K. Sinha was prepared on 8/11/98, which in detail talked about this problem.
Then comes that reply to the unstarred
Yes,
question,
yes,
14
yes.
July 2004.
Absolutely, absolutely. my
And
lord.
the writ petition Sarbanand Sonowal, you say, was filed in 2000.
Absolutely. And this actually considers the Assam Accord in para 18 and in para 33 in great detail. The next point, I will just on the legislative competence, I just want to point out one article just for the purposes of saying that how 5, 6, and 7, articles 5, 6, and 7, the purpose was that they would work themselves out at the commencement of the Constitution. I only want to point out Article 394. If I may read, this article and Articles 5, 6, 7, 8, 9, 60, 324, 366, 367 shall come into force at once, and the remaining provisions of this Constitution shall come into force on the 26th day of January 1950, which day is referred to in this Constitution as the commencement of this Constitution. So therefore, my lords, the 5, 6, 7 sections, articles were supposed to come into effect on 26 November 1949, and therefore at the commencement of the Constitution, therefore by 26 January 1950, they were supposed to come into play for the grant of citizenship. And thereafter, therefore, we have said that the purpose of Article 11 was only to add, not to deprive anybody, but to add a certain class of persons which were not covered by Articles 5 to 9. That is the point that I've covered in point 4. I've also given detailed submissions, my lords, which is there already on record. Another judgment that I wanted to add, because Izhar Ahmad, when it discusses in great detail Article 11, it is a Constitution bench judgment. It is very clear on what Article 11 entails, and it has been followed in state of UP versus Shah Mohammad. I have given the volume number and the pages, and also the para 5 of state of UP versus Shah Mohammad. It's a case very similar to Izhar Ahmad, and it follows Izhar Ahmad, and again reiterates that Article 11 is supposed to then come into play for the purposes of the laws to be made for citizenship. My fifth point, very briefly, I have tried to state that Section 6A is not the only statutory provision to be based on a political agreement. And I have given two instances for this, Article 371A, which is the 13th Amendment Act, and it is based on the agreement between the Government of India and the leaders of the Naga People's Convention. Then I've also cited 6th Schedule, which is which is based on the Memorandum of Settlement entered into between the Government of India, Government of Assam, and Bodo Liberation Tigers, and this is now on the autonomous districts and autonomous regions. It covers the areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Then I have just added some case law to say that the classification on the basis of historical or geographical reasons is absolutely valid. And therefore, I have only added the judgment in state of MP versus Bhopal Sugar was already cited before my lords. I have only added one more judgment on geographical classification, which is Ram Krishna Dalmia versus Justice S.R. Tendolkar. And I have also added Clarence Pai versus Union of India. And in the end, I'm only making a point that if the history of this agitation is seen, it is actually wonderfully spelled out in the Quest for Modern Assam, which is also a part of volume 4A by Arup Jyoti Sakhya. It will be very clear that what had happened throughout this process and why, because of the Bihar settlers, why because of the Bengali language, and why this agitation became much more than what the people of Assam could handle, and therefore for peace and normalcy, the Section 6A was brought about.
Thank you so much. Thank you, Mr. Reddy.
May it please your lordship. Well, I'll make a very quick fire 5 points. So your lordships will not have to be.
You are in IA, what, 24
Well,
of
the IA,
2017?
the IA that Malaj is 24 of 2017.
Assam State Jamiyat Ulema e
That's
Hind.
right, the state Jamiyat. Malaj, we've been deeply involved in all the CAA matters, etc., and we've been involved in the Assam Accord settlement right from the beginning. Malaj, we have I will not repeat anything that my learned colleagues have said.
Where is your note, Mr. One?
Mullah, your lordship will find the note in volume 2C at
2C.
pages 5 to 6. PDF page 7.
Yes.
And my lords, the earlier note that I had given, what your lordship will find in volume 2, there's the details are all given there. This is very, very brief because your lordships want to just say.
Let's have a look at your note, Mr. Sashi.
So if your lordship will see at PDF page 7, volume 2C, well, it's the first point. If your lordship will focus on that, the first point essentially is to disclose that the migration issue is a global issue, and for Assam it continued over centuries. So it wasn't as though something had suddenly happened, and the amalgam of different communities moving into migration, bringing different communities into Assam gave what sociologists have said is a salad bowl. So there's two perceptions about a salad bowl and about a mosaic, or on the other hand, it would be a melting pot. So the preferred view seems to be of a salad bowl. This is how it existed. But of course, as your lordships have heard from the others, there were issues that were different as far as the western border was concerned and the eastern border. The issues on the eastern border was the constant move from one part of Bengal to another part of Bengal. So Assam was in a sense separate because they didn't want to impact on the issues between the two parts of Bengal. Assam then therefore becomes in a sense collateral to that issue. So Assam issue was never resolved in terms of the permit system that was introduced in the West. And the permit system, your lordships might recall, was particularly focused on the issue that people who had left and their homes had been given to refugees coming in from western part or from West Pakistan could not then be asked to evacuate their homes that they were given as refugees to return to people who had come back. And therefore, the permit system was particularly carefully monitored. This didn't happen in the eastern part, and particularly as your lordship saw Justice Baharul Islam's judgment, his speech in the Rajya Sabha, we've mentioned all that here, my lords, and therefore a separate issue had to be framed as far as the eastern side was concerned. And that, of course, the 64 was an obviously a landmark point, 64. 66 follows because 64 follows with the 67 electoral rolls. But the critical matter, my lords, is the 1971. 1971, if your lordship will see here in point number 2, if your lordship will see, Bangladesh had already introduced their citizenship law in 1972. We were introducing in 1985. So in effect, the 1971 aligns itself with the Bangladesh law. So there is no gap between Indian citizenship and Bangladesh citizenship. Your lordships were asking if it had something to do with Operation Searchlight and the migrations that would have been caused due to distress because of the Pakistani army operating. The Bangladesh government said they would take back all the people who had moved during that period. Because if they were in Bangladesh on the first day, which was on 25th of March, they would be citizens under the 72 law. And therefore, we were only concerned with people who were not in Bangladesh on the 25th of March. Those citizens would be taken care of, or those people would be taken care of by the Indian law. And it aligns. Now, my lords, if for any reason the 71 is changed for any reason, it would mean that 40 years later, there are a huge number of stateless citizens, something to which we are not yet signed as far as the convention is concerned. But Government of India has always been careful about not creating or not being seen in the world as creating stateless citizens. And that is very critical point why your lordships would wish to uphold the 71 as the so-called cutoff date, though there is some issue about whether it should be called the cutoff date at all. So, my lords, that's point number 2 in my submissions. And my lords, point number 3 only follows upon what arguments have already been made, that it didn't freeze, the issue of citizenship didn't freeze in 1948 under the Citizenship Act of 1955. It continued with 6A, and then it continued subsequently in 2019 when further amendments were made for citizenship. Those may well be under challenge, but at least in theory, it was possible for the citizenship to continue in terms of fresh legislation. Then, my lords, the last 2 important points are, now there is a fresh affidavit that's been filed by Government of India. Those 2 points, the last 2 points, 4 and 5, indicate that the alarming picture that somehow emerged is not, my learned friends just before me had indicated this, but that alarming picture was misplaced, that the number of people so-called coming in was completely misplaced. Firstly, because the migration figures, as we now see from the affidavit, are much less compared to the ones that have been projected earlier. And then, my lords, in view of this affidavit, I would urge your lordships to consider whether the monitoring bench is the appropriate bench to continue with any issues that are indicated for future, and many of those issues are mentioned in the affidavit, rather than this honorable bench having to worry about what to do about the future prospects.
Thank you, Mr.
So, my lords, the only issue to recall is whether we are a salad bowl or we are a melting pot. Well, that's very critical in terms of sociology to understand. Your lordships have already been told about how the cultural issue was protected by the schedules, by which the culture and autonomy of the tribes of Assam was protected. And they are the ones who should really have been concerned, not the others. This is my submission. Deeply obliged, my lords.
Yes, Mr.
I won't take more than 2 minutes, Miller.
Yes.
My application, Miller, IA